ICE has a pattern of disregarding the law. That's according to a federal judge who this week ordered ICE to better follow the legally required steps that they're supposed to follow when making arrests without warrants. So here's what happened. 4 plaintiffs sued, saying that they were arrested without warrants and without these protocols being followed. One of those plaintiffs, you might remember, is Caroline Diaz-Gonçalves, a Utah student who was pulled over and detained in I-70. She and 3 others said that they were arrested without warrants and that ICE did not do what's called a flight risk assessment to determine how likely that person is to flee. That's required of them and has not been getting done, according to this federal judge. DHS, or the Department of Homeland Security, is calling this a brazen activist order. So what's supposed to happen? 1, they're supposed to get these warrants, and 2, if they don't have a warrant, they're supposed to have a probable cause, as well as this flight risk assessment to determine if someone's gonna flee. If they do find that someone's unlikely to flee, right, they have community ties, they're not supposed to detain them. Now, there is a little bit of concern, right, that ICE is going to try to skirt around these rules. Essentially, what can happen is that ICE officers do have the authority to write an administrative warrant right on the scene. So, will it actually impact? That is the biggest question. Attorneys are ultimately hopeful, but we should see this case continue to be litigated and appealed. So we'll continue to watch this one.